And then my second issue was pursuant to the raft landlord contract. It states that the landlord agrees not to pursue eviction based on rent amounts reimbursed by these funds and agree to dismiss any pending eviction case that is based on or seeks to recover the reimbursed arrears. And it is clear by looking at the judgment, the amount clearly includes the reimbursed amount of $3,240 from Raft. And that award letter showing that was going to be paid was issued on August 19th. And then on September 1st, the plaintiff sought and got judgment for the full amount of $10,532.
The agreement that you were just quoting me from, is that the July 14th agreement, or is that
Correct,
one?
Yes.
Because was there a previous case that was settled?
I'm sorry, it's June 14th, not July 14th. I'm sorry, June 14th.
Okay. I mean, so it sounds to me so far most of your issues have to do with the amount of money and where it's being paid. It doesn't sound like me like you're making any don't have any issues about your about actually staying in the unit.
Well, yeah, well, my issue is that the whole case should be dismissed based on that contract.
And so, you raised those issues in, there are two motions that you filed after the judgment, after the execution issued. You filed on September 8th, you filed a motion for a stay, correct?
Correct.
And then September 14th, I want to say, maybe September 16th, you filed a motion to vacate the judgment based on the on these arguments you're making now.
Yes, correct.
Okay. So I mean, there is a technical issue here in that generally an appeal bond comes from the judgment of possession, and it's it wouldn't usually come out of a motion for a stay. And it might come out of a motion to vacate the judgment, but you obtained the appeal bond proceedings that were before you filed that motion. That's what I'm kind of I find the proceedings a little confusing. I'm sure you do too.
So I tried to raise these issues when I went in for my hearing for the motion to stay, and it was never heard. And I ended up filing a motion after to be able to supplement the record with my exhibits that I had, and it was denied. So my exhibits were never considered that day when I went in for the hearing for the motion to stay.
Have you submitted those exhibits to me or no?
No, it was to the housing court.
Okay. And what information was in those exhibits?
Well, I mean, there was a bunch of things in there. It was like 15 or so exhibits in support of my arguments that I'm making now.
Okay. It must have had to do with with the money that was coming and going. And did you pay the $540 in July and August?
Yes, I did.
And did you pay it for September and October?
No, because my income, we lost our income. The only income I have right now is TAFDC under the disability supplement through DTA. And the housing is now in the process, and they've been in this process for quite a bit now, to adjust my rent amount because we had a significant loss in income. So as I said, the only income my household has right now is TAFDC. But housing is working to adjust all that and recertify me. I mean, this has been going on for months now.
Yeah. So let me just,
So I don't know what my portion is.
Right. I mean, let me just, I've got like 3 more minutes left on your clock for now, but tell me what would you like the single justice of the appeals court to do? What would be, what is the outcome you're asking for?
To waive the bond and allow my appeal to go through and stay the proceedings.
And so, okay. All right. So, I mean, actually, what you mean is for me to allow your motion to not have to waive the bond, so you don't have to put up money up front. If I were to do that, though, I would certainly require a monthly payment. And is the and
the housing court judge issued that already. I'm sorry, I didn't mean to interrupt you.
No, that's okay.
The housing court issued that to start after the 3rd of October and make payment the 1st of every month.
How much?
I mean, I have another apartment. I plan to be moving out of here on or before the 1st of November. Like, that's a definite. I got an apartment there. The housing has all the paperwork from myself, from the new landlord, to put through by the 1st, if not before.
So if I granted a further stay for 13 days, you'd be fine?
Yes. Yep, I should be fine.
Okay. So I unless you have anything else you want to add, I'm going to hear from Attorney Greenman.
No, that's it, Justice. Thank you.
Okay. Attorney Greenman, where do you want to start?
Thank you. First, I want to correct a couple of things. My client, we did not get a judgment on September 1st. We got a judgment on June 14th when we signed the agreement for judgment. As your honor should know, tenants cannot ask a judge to, change an agreement that they sign. The agreement was the agreement. The reason the appeals bond was issued was because she did file a motion to vacate the judgment, and she filed simultaneously a motion to waive appeal bond. So the judge did what he was asked to do by Ms. Silva. This entire appeal is an attempt to end around the system that provides for certain things. And to answer the direct question that was sent to the parties, yes, it was appropriate to issue an appeal bond because, in essence, this tenant did appeal from the judgment. Despite signing an agreement for judgment that states quite clearly that she will not appeal, she did appeal. She completely stopped paying. And the amount of the bond is the amount that she owes. The agreement for judgment did not provide that the landlord should have to comply with any kind of rule to dismiss a case. It was an agreement for judgment that anticipated that the arrears of $10,532 would be paid by RAFT. That is not what happened. She, upon information and belief, didn't even apply for that amount of money, although we don't know and we can't know. And on September 2nd, one day after I requested the execution, my client received a check from RAFT for, I believe it was either $2,500 or it was some very small portion of what the total judgment was. It is in escrow. We fully believe this tenant continues to owe the money. Whether a RAFT has a date on it of August 19th, it was not sent to my client. The issues absolutely are frivolous. We would not have entered this agreement but for her agreement to leave August 31st. The entire basis of this agreement and why we did not go to trial that day was because she agreed to leave August 31st. Everything that we agreed to fell into that promise. This tenant and my client this is the third summary process case between the parties. And my client has been working to have this tenant removed for 4 years. They're entitled to it. The appeals court, the bond was issued pursuant to the case law, Tamper v. DeRozier and US v. Johnson. And the last minute attempt to, this is not also the first, last Tuesday was not the first time that this tenant has claimed to have COVID and been unable to come to court. It happens every single time my clients try to actually access the property for repairs. Somebody in the house has COVID. So this is just an attempt to end run around the system. There is no legal entitlement. My client has judgment for possession. The execution will expire if we don't use it. And my clients are entitled to the benefit of their bargain, which was that she would leave August 31st. Not only did she not leave, but she has made the hole deeper by not paying use and occupancy, by coming up with creative arguments written by her husband that she shouldn't have to pay a cancellation fee that my client paid. My client paid the cancellation fee. She was ordered to pay it. She did not do so. She also did not pay her use and occupancy. So she has done nothing that would signal somebody who actually wanted to maintain what they have, which is to do the minimum amount necessary in order to keep possession of the property, not, stop the bleeding, for lack of a better term.
When does your execution expire?
Well, for possession, for possession, it would not expire until 90 days after it was issued.
And it issued a while ago, though, right?
Yes.
Or actually, not. It is September 1st, right?
Yes. But to continue this going, it's also notable. This court might be interested. I did not know what category to file it under, but this tenant is on something called a probationary period with the housing authority for failure to comply with their requirements. So we don't actually know that anybody is ever going to approve a move. We have not seen a lease. Nothing has been suggested. And at the hearing before the housing court, the defendant admitted that she did not have any place to go or prospects, that she just wanted more time. And when he asked her specifically, do you have another legal argument? She said, I just don't want to be homeless. And he explained that that's a sympathetic position, but it's not a legal argument. The argument about raft, it's not. Raft requires that you dismiss a case where you get payment in full for what's owed. That's not what happened. And this was not a non-payment case in any event. It was a for cause case.
So if I were to, deny any relief today, what would your next course be?
We would reschedule with the 48-hour notice. We were allowed to do that as of September 15th when she didn't make the first payment, but because of the appeal, we have been unable to. And then, my client has wanted to gain access to the property for safety reasons, but what I explained is that I don't even think I can file that kind of motion with housing court right now because the jurisdiction is out of the housing court's hands right now.
Because it's here?
Yes. But we are very concerned about what's going on inside of that apartment, and my client really does want access to it. Okay. Anything else you want to inform me of, or ask, or relief you want to ask for?
Yeah.
Miss Silva, I'm still talking to Ms. Greenman. Hold on.
I'm sorry. I thought you said me. Yeah, I'm sorry.
I just do think it's important to note that she, one of the reasons for this case being brought in the first place was that she had an unauthorized occupant. That unauthorized occupant is her husband, who apparently spent lots of time in a law library at some point in time for reasons I don't need to get into, and has been behind all of these massive filings made by Ms. Silva. And it is very clear that he is still occupying the property. And nonetheless, my client has just lost all control of this apartment. They don't know who's there. They don't know what's going on. They're not getting paid for anything, not even use and occupancy. We're getting letters from the housing authority that her voucher is going to be terminated. So, time is of the essence in that regard.
Okay. All right. Thank you. So now, Ms. Silva, do you want to respond? I'll give you a few minutes.
Yes. Okay. So as far as this agreement that she continues to talk about that we made it in the housing court that that I didn't apply for enough funds from RAFT, and I only applied for a small amount. First of all, I have no control over what RAFT pays. I apply, they pay what they pay. I have no control over that. And they knew, the plaintiffs absolutely 100% knew they were only going to get $32.40 from them, because it was discussed in the meeting with my attorney. It was discussed. So, and also if they were expecting to receive the whole $10,000, why would they say they'd waive the balance if there wasn't going to be a balance? So they knew they were only going to get $32.40 from RAFT, and they agreed to waive the remaining amount if I paid those two payments for July and August and applied for RAFT, which I did. And the balance of the judgment was never waived. And it also was, and it's still not deducted from the amount of the judgment. I mean, the bond was issued for the full amount of $10,532. How come the $3,240 wasn't even deducted from that amount? And all this talk about unoccupied occupants and all that, it was already confirmed that that person doesn't live here. And who's helping me with my court paperwork is none of her concern to begin with, or for her to even be mentioning that to you. And me wanting more time and me lying about COVID. I mean, this is just a never-ending nightmare. And this whole eviction is based off violating terms of a lease. Justice, I don't have a lease with these people. I never have. I've never had no sort of rental agreement with them, with this new guy, ever. I've never signed no paper agreeing to anything with this new owner. There was never no lease. There was never no rental agreement. He raised my rent, what was it, $400 more a month, which I never agreed to. He never gave me no, oh, this is going to be your new rent. Do you agree? Sign. Never signed nothing. He never gave me nothing to sign agreeing to it. I stated right from the beginning I couldn't afford that because housing wasn't going to pay that. I would have to pay the additional, and that rent increase amount is included in all this amount that they're saying I owe. So I don't know how I can, first of all, owe money from a rent increase that I never agreed to pay in the first place. And this whole eviction is based off me by certain violating terms of a lease, and I don't have a lease. I've never seen this lease. I've never signed a lease. I've never even seen the landlord, for that matter. And I'm not doing this just for looking for more time. Yes, I did need more time, but that is not my basis for filing these motions. I'm trying to protect my rights here, which I have every right in the world to do, and that's exactly what I'm doing. I found something wrong with it, and I chose to file motions to get it looked at. That's it. It's not all, oh, I'm just trying to get more time. I'm just trying to, stay here. Trust me, I want to be out of here just as much as they want me out of here. I just feel my rights were violated, and I just wanted to have it looked at. That's it. I want to protect my rights. That's my whole basis for doing that, for filing these motions.
Okay. I just want to I think I understand your point, Ms. Silva. I've got one more question for Attorney Greenman, which is I've got the agreement up on my screen over here. Number 4 is tenants will apply for RAFT funds to pay judgment above if RAFT if RAFT issues an award letter, landlord will waive balance of judgment. I think it's if RAFT issues an order and July and August are paid, landlord will waive balance of judgment. Is that accurate?
Yes, but again,
yes.
It was September 1st. My client still didn't have the check in their hand from RAFT. I ordered the execution in the ordinary
award
course,
letter,
as I do with every case. And it issued the same day.
Okay. All right.
The agreement was issued based off of the award letter, not payment. It says the award letter, and that was issued on August 19th.
Notwithstanding,
Before the judge.
Silva left the property on August 31st as she was supposed to, I guarantee I would have done what I needed to do and filed a satisfaction of judgment with the housing court. It would have been waived. She did not leave. And
That
we
was
did not
a
have the
voluntary
money.
term.
When
Mr. Owens, please don't interrupt. Go ahead, Ms. Attorney Greenman.
And just to address the issue with a lease, you cannot be a Section 8 tenant and not be subject to a lease. Every Section 8 tenant in the state has an HAP contract that they are to abide by. The HAP contract itself states the way that it gets transferred when a building is bought. And that's exactly what happened. There's no lease. There are program rules. That is the only rule that is being referred to. And the lease also transferred at the closing. Whether her prior landlord told her that or not, I couldn't know. She signed this lease in 2011.
Understood. Okay, I think this has been helpful. I thank you both. I will have to take this under advisement and look through all the papers. But I understand for both of you, particularly for Mr. Resnick, time is of the essence. So I'll get to it as quickly as I can. Thank you both.
Thank you.
Thank you.